And Gabby, as always, if you can tell me when you're set to go, I'll begin talking. Can you imagine that? Very good. Well, good evening, everyone. My name once again is Jim Santel. Delighted to have you with us tonight. Right before we began this evening, we had a wonderful statement from the executive director of our good organization here, Blue Sky Waukesha, and the founder of it, about the recent death of the county executive of Waukesha County, Paul Farrow. And Kristen will be noting that, I'm sure, in the communications from Blue Sky Waukesha as well. We think about Paul and his family tonight in memory of the good work that he's done for the community and the person that he has been. And so tonight we're going to continue our work through the various amendments to the Constitution. Yes, indeed, there are lots and lots of words up there, including 4th, 5th, 6th, 8th, 9th, and 10th amendments. Earlier in the week, Kristen said, can you get through all of that? And the answer is yes, we're going to do our very best to do just that. We're going to be a little bit more expedited than we have been in recent weeks. And then we're going to spend some time talking, believe it or not, about what lawyers do. And believe it or not, once again, the portion of the evening that I'm looking forward to most is just that. And so we've got some lighthearted things. We'll make references to where some of our language about lawyers comes from, and then also talk about some of the specific roles of lawyers and attorneys when it comes to executing on the rule of law in America and beyond. A big agenda, but we can always get through it, and as always, taking questions along the way. We thought that we would start, again, as we have in the past, by talking a little bit about current events, not here in Waukesha County, but certainly in the state of Wisconsin generally, in the American nation more broadly, but also in Milwaukee County. Just yesterday, as I suspect all of you know, now former Wisconsin Circuit Court Judge Hannah Dugan was sentenced. That comes, as the slide indicates, in the wake, obviously, of her conviction last December on one count, a felony count of obstruction of justice. She was acquitted, as you know, of a misdemeanor count of concealment. And since that time, the judge, his name is Judge Lynn Edelman, there he is up on the screen as well, has entertained various motions, post-conviction motions, seeking from defense counsel to overturn that judgment of the jury, various things having to do with the nature of the charges, and in particular the fact that the judge gave some jury instructions, you may remember, that many people feel resulted in this so-called split verdict between the two, premised upon the same facts, obviously different statutory configuration, but that also a part of the judge's disposition. He has denied all those motions. He recently began to entertain another motion, which is also not frivolous, having to do with a Fourth Circuit case, again, a case coming out of the United States Court of Appeals for the Fourth Circuit, the Mid-Atlantic states, in which the court made a distinction between two concepts, and I suspect you're all going to smile broadly when I say this because you're going to think, yes, that's the way lawyers talk, that they made a distinction between immigration proceedings and deportation operations. And if you think about it, there is sort of a distinction between them, and the reason why that is significant coming out of, again, the Fourth Circuit, not the Seventh Circuit, is that locally, our prosecutors charged, and Hannah Dugan was convicted, of obstruction in connection with an immigration proceeding. And the question is, well, wasn't this matter involving the arrest of the defendant who was appearing in front of her more in the nature of a deportation operation, where they were there to try to arrest him? They in fact did. There was a race, as you know, outside of the courthouse. That should never happen in the future, should never happen in the past. But there was that question about whether or not Hernandez would basically require, stunningly, the judge to look at all this and say, you know what, this case was improperly charged, therefore the conviction of her based upon this linguistic difference cannot stand. He could have vacated the judgment and ordered not only a new trial, but candidly, under these circumstances, would have had to direct, if the government wanted to do it, the filing of a new indictment that cleans up the language. In the end, as you see here, the judge, and you can read his order, found that in fact this was a pending proceeding, that is the attempt to arrest this fellow, Flores Ruiz, in her vicinity, in her courtroom. With due respect to Judge Edelman, an awful lot of people looked at that and said, well, it's really not so much a proceeding, but he did find that the case did not apply, at least the Fourth Circuit precedent didn't, and then once again denied the motion that would have brought this particular prosecution to an end. He rescheduled the sentencing hearing then for just yesterday. As you know, the result of this, he made the decision not to impose any jail time at all, which again is significant under the sentencing guidelines and the statute there, and found that a $5,000 fine, however, would be appropriate. She is not on any sort of supervised release or probation, does not have to show up for any sort of routine meetings with a probation officer. And among other things, I thought it was interesting that Judge Dugan, much to her credit, did exercise her right to speak to the judge at the time. You can take a look at all of that, but among the things she said, she of course did not say that, yes, indeed, I committed this crime, but she said, I'm a good public servant, and I've spent 9 years on the bench doing just that. And she dismissed the notion that she was either a hero, as she said, or a scofflaw. I'm neither one of those. She said, I'm somebody who's trying to do their job and found myself in this very difficult position, and indicated more than implicitly that she will continue to serve in whatever capacity she can in the future, plainly not on the bench. A lot of questions about her own future. And in particular, the question about what is her legal status. She is still a lawyer in the state of Wisconsin. After all of this is done, which we'll get to in just a moment or so, it's highly likely that the Bar Association, which we all have to be a part of, will take a look at this situation. Under bar rules, you're required to report yourself if you've suffered a felony conviction, and she has. They may well wait until all of this is disposed of. We'll talk about the appeal in just a moment or so. But she does have that ahead of her as well. Not at all clear that they will either continue with her licensing or in some way suspend it or terminate it. Just because you're convicted does not mean that you lose your license. And so they'll take a look at the merits of this, and do I suspect much of what Judge Edelman did in imposing a sentence. As you see there, he also says that this was not someone engaged in public corruption. This was someone, as he said, who made a decision in the moment. He said it was a bad decision, but it is distinguishable from many other cases. So that issue is still out there, as is the issue related to an appeal. The matter is now completely resolved, finally, after all these months in front of Judge Edelman, and so it goes well now to the Seventh Circuit. I'm not going to throw up on the screen again tonight my favorite slide, which shows you once again, you all know what it is. It's the slide of our districts and our circuits, but that is where she would go, which is to the United States Court of Appeals, the Seventh Circuit. I've had some questions just in the past couple of days, including some from the media, which we respect and honor a whole lot in America, but nonetheless suggesting that they've got a different view about what happens on appeal. No, you do not get a new trial on appeal. In fact, it's 3 judges who sit in the Court of Appeals from the Seventh Circuit. They're on the 27th floor of the Dirksen building. You can go down there and watch their oral arguments routinely, and they will pepper the lawyers, both for the prosecution and the defense, with various questions about whether or not the decisions made by Judge Edelman over the period of the last several months, including everything from pretrial dispositions, jury selection, jury instructions, evidentiary rulings about testimony before the jury, specifically what happens after the judgment came back on this Hernandez matter. All of those things can be the subject of an attack on this conviction that could get to the Court of Appeals. That's pretty much defined by the defense and by the attorneys there. And presumably that proceeding will continue over the summer. That includes the filing of briefs by the attorneys, probably an oral argument at some point down the road, maybe late summer, more likely in the fall, and yes, indeed, a judgment from the Court of Appeals on whether to affirm, uphold, or in some way reverse this decision, probably, hold on, sometime next year. In 2027. That's not unusual given the fact that we're halfway through this year already. And then, of course, as you also know, because you're all good students of the process here, is she may, if in fact the Seventh Circuit affirms the conviction, supports everything that Judge Edelman has done and the jury decision, she could seek a writ of certiorari from the United States Supreme Court. And again, highly unlikely that they would grant it, but you never know. This case doesn't present any especially unusual issues aside from this thing out of the Fourth Circuit, but they could if in fact it gets sufficient notoriety. And so we'll see. If that is the case, we're probably talking 2028 or 2029 before this final judgment is entered, and it would probably be after that, if then, that the Bar Association would take up her status as a lawyer. She has indicated that she will continue to be a part of the community as she has been, and that was also part of the sentencing hearing yesterday. So that's the update on all of that as of this time, and it certainly is not quite done. We've got a question. Yes, please. So that is a good question. The question is it possible that she can run to be a judge once again? And that would be an open question. Again, you do not have to be, someone who is, as we know, you can serve in public positions having suffered felony convictions. The President of the United States of America falls into that category. A lot would happen, I think, depend upon what the Bar Association does. And she plainly has resigned from the judiciary, so she's no longer a part of that. But depending upon the specific rules that might apply to that, it's entirely possible she could. My own guess is that although she's very young, and everyone needs to repeat that very quickly, in her mid-60s, that's very young, by the way, for everyone to know, she certainly has a career ahead of her doing other things, including representing clients, maybe serving on behalf of nonprofit organizations, doing other things, including engaging with Blue Sky Waukesha down the road on education. She does a lot of that. So this is not the last you've heard of her by any means in this case, and down the road, all avenues, at least right now, are very much open to her. Great question. Anything else related to this? Yes, please.
Well, under the law, even if she were to get disbarred, she could still run for judge again.
Absolutely. Right, exactly. For what it's worth, you do not have to be a lawyer to be a member of the United States Supreme Court. And right, exactly, right? It's always important to remember that. So many opportunities out there. Yes?
With all these high-powered lawyers that took a case, would there be an incentive for them to continue on, just to make it be noticed nationally?
We're going to get to the lawyer jokes later in the program, I promise you, including some invocations of that. I love them, by the way, just to go on the record. I've got my own, and I'm not going to put them on the record tonight, but they're wonderful. The answer is that we do have some high-powered lawyers. I'd like to think that my successor in the U.S. predecessor, a fellow named Stephen Biskupik, who handled the trial, he is on this team. Paul Clement, who again is of Wisconsin, the Green Bay area, I think, Brown County, is going to be taking this up on appeal. He is a former Solicitor General, lots of appearances before the United States Supreme Court, an excellent advocate in the appellate setting. So lots of lawyers out there looking to this. Whether or not, I'd like to think that people of that quality would not use this as an opportunity to further extend it, and they've got limited periods of opportunities to do just that. The Court of Appeals will set a briefing schedule. You have to comply with that. When they say, come down here, Paul Clement, to argue the case, you need to show up on that date, and they will issue the orders when they're ready to do so. So it's difficult to do that. In the meantime, again, the notoriety of the attorneys, I think the question is well placed, does continue to keep the case in the public eye. I was interested to note that I don't believe, correct me if I'm wrong, the president himself has commented about this, although he did earlier on. New York Times has followed this and issued some reporting on it. So it continues to have some national notoriety, including for lawyers, and we'll talk more about attorneys and what they do and what they don't do about halfway through our program this evening. Any other questions about that? Very good. All right, so let us move on to various amendments. We're going to spend some time principally tonight, and they're going to go more quickly as we move through them, talking about the Fourth Amendment. And in designing this with Kristen and other members of the board and members leadership of Blue Sky Waukesha, it occurred to us that many of the best examples of how these various amendments are in place, as it was in our examination of the First and Second Amendment last time, are examples of how the amendments and the principles in them are sometimes abused. And so it's not difficult to find, regrettably, in our recent reporting of America, instances where things like the Fourth Amendment, there you see it, has been abused, regrettably, by the Department of Justice and others. And you know this well, you've read it, and I'd like to think that other members of our government have done the same thing. Note, again, this is James Madison writing. Notice that the right of the people, again, to be secure basically in their home, right? The home is regarded under the Fourth Amendment and all sorts of constitutional principles decided by the Supreme Court as the ultimate place of privacy, right? You close your door, and in order to have the government come in and search, you've got to go through a number of hoops, and we'll address that in just a moment or so. Note that the amendment doesn't say you can be free from all searches and seizures. Notice that word unreasonable. And that packs a wallop, because what it means is government cannot abuse that notion, cannot simply come to your door, except for some recent events, which we'll highlight, and knock your door down without process that precedes all of that. The word unreasonable is interpreted to mean due process, and the only way, the ultimate way to get into a home, the ultimate place of privacy, is to prove to a magistrate, a federal judge, that there is evidence in that location of a crime. And I'll show you how that happens in just a moment. I did this routinely when I was an assistant U.S. attorney and a U.S. attorney. Again, the fact that the Fourth Amendment describes this in great detail, unlike the Fifth Amendment, which we'll see next, this is not one of those that is sort of an omnibus statement of all kinds of rights. This focuses upon searches of your home, your business, frankly, your cell phone, your other places that you may have some interest in privacy. Note again, it's got to be upon oath or affirmation. What does that mean? It means you've got to have somebody come in to testify in front of a judge to say, this is what I found. This is the reason why there's probable cause to believe that in Jim Santel's home there'll be evidence of a crime. I like to think that's not the case, but I'll use it as an example here. And note also the requirements of particularity, the persons, the places. When judges issue search warrants, they do not simply say, go ahead, search. It's very specific as to time, place, and circumstances. Let's talk about that a little bit right now. There is again, kind of the encapsulation of that process. The way this happens is, of course, you've got agents or law enforcement folks who are out there. You cannot simply show up in front of a judge and say, again, I don't like that Santel fellow. Let's see what's in his house. Let's see if he's doing anything that's illegal. That is not probable cause, and I'd like to think that every magistrate, every federal judge in America, every state judge would look at you as a prosecutor and say, get out of my chambers. You have to have some predicate, and it's got to be probable cause. This is more than just a reason to believe that somebody, or a suspicion, reasonable suspicion, which is the standard for detention or arrest. You've got to have probable cause, and what is that? Well, it's the kind of thing that you would know when you see it. It is more than just a hunch, obviously. I've got to have some witness who's come forward and would say, I've been inside the home, I've seen the methamphetamine lab, I've seen people come and go, I've seen the money come and go, I've seen the guns, those kinds of things. Something that puts the crime right there inside the house. And also, I've seen it recently. Especially with drug cases, as you can well imagine. The judges would always ask me, Mr. Santel, what is the recency of this? And if I come back and say, well, this is 4 weeks ago, Judge, again, the response would be, get out of my chambers, because of the nature of drugs, right? Other things, guns, may be a bit more fluid also, but money maybe also, but depending upon the thing that you're looking for, it's got to be recent and current, and the more recent it is, the better your probable cause is. You've got to establish reliability for the agent who's coming in and testifying. This is what the result of my investigation has been to date. You do not have to have proof beyond a reasonable doubt. That's the criminal law standard at trial. But you've got to be able to convince the judge that if you go in, there's a strong likelihood that today, existing in that property, there is evidence of a crime, and we know it because I've spoken to this credible person. I've seen something. I've done document searches. I've looked at bank records, and all of that indicates that in this place, which could include a safety deposit box, could include your business. As I said, we also have to get search warrants for various forms of electronic devices now in our 21st century age. All of that has to be a part of this process. Judges, again, as I said, will limit the ways in which you can execute a warrant. Typically, they will say, I don't want you showing up before 6 a.m. in the morning, and I don't want you doing this after midnight. Let's do this in daylight hours when things can be accounted for. You may recall cases involving no-knock warrants. The presumption is that when you come to the door, agents or the officer will pound on the door 3 times and say, police, we have a search warrant. Typically, the recommendation is from Supreme Court cases that you do that in sequence. You can do it fairly quickly, but 3 times to get the attention of the person inside, that's a knock warrant. There's a presumption that you knock first before you batter down the door. Judges can indeed issue what's called a no-knock warrant, and we've seen that in a number of instances. It is not always as successful. We've seen that as well. Tragedy can sometimes happen. There, what you're doing is you're coming up to the home, and without any warning at all, you've got authorization to batter through the door and bring it down. And people inside, of course, are routinely very surprised by that. It can, in sometimes, cause great problems. Not to say there aren't appropriate circumstances. When you are concerned about the immediate destruction of the evidence, again, knocking 3 times, maybe it's 30 seconds, that's the time when you can also run to the toilet and flush things down the toilet. You can get rid of things. And so that's a determination, but also specific instructions given by the judge based upon what you presented. The other part of this that has to be known is that there are an awful lot of questions that are asked. Mr. Santel, tell me more about the neighborhood. Tell me more about the circumstances that resulted in this investigation being started. And in all of that, and this is another important thing that's been going on recently, there's been a presumption of regularity, and that is if a judge looks at you, whether you're an assistant U.S. attorney or an assistant district attorney, and asks you a question like that, I shouldn't have to say this out loud, but I do in 2026. The responsibility that you have as a prosecutor asking for this extraordinary thing to make an entry into this supremely private place, a home or a business, is that you tell the truth, right? And if you don't know what you say, I don't know, Your Honor, I will get the information and get back to you. You don't lie. And we have benefited, I benefited for my entire career from what's called the presumption of regularity. It's not putting the government in a better spot than anybody else would be, but simply that notion that if you are representing the government, you don't lie about things. And the judges can rely upon the honesty and the forthrightness. You know from a lot of proceedings in the public, and some involving this kind of thing as well, that more and more judges are saying you have violated the trust, and the presumption of regularity when it comes to talking with judges no longer exists. We've seen that in many courts, and so it has to be affecting, frankly, judges who are now approached by assistant U.S. attorneys who are making these representations, whereas before there was a presumption that, yes, of course, Jim Santel will tell you the truth. Now, that has been severely compromised by virtue of what this Department of Justice has done. That's not just my statement. That's what judges are saying around the country. We've got some questions about this process. Please.
I'm just wondering, where does ICE fit in there where they don't have to get a judicial warrant? They just batter down the door and go in?
It's almost as if we have coordinated on this presentation tonight, right? We didn't, I will tell you, but outstanding question. I'll get back to others as well. That's the process. Whoops, I need to go back here and look at this. There it is. We really did not coordinate this as well. Here is what, again, from my perspective, is an out-and-out violation of the Fourth Amendment. What you have here, these are pictures, again, Minneapolis, other places. There is a memorandum that's issued inside the ICE legal offices that says, you know what, those judicial warrant things, no, you don't need to do that. If you, in fact, get authorization from an internal form, you've got to get some authorization. But if you go down the hallway and fill out this form, it's called Form I-205, and somebody administratively gives you authorization to batter down the front door, you can go in, and that's what they did in some of these cities. Those are pictures from that. Of course, eventually, when this comes forward, it's not a judge. We had judges saying, what is going on here? We do not have the agencies giving themselves authorization to go in and execute warrants. Magistrates do that, judges do that, state and federal judges do that, and eventually this is abandoned, and the memorandum, I think, has been pretty much abandoned, but it was put together for this specific purpose of undermining exactly what I just described. And in the end, what we have is a number of judges out there recoiling in absolute dismay and horror that this is happening, and one of them, of course, identifying that we took a battering ram not just to the doors, but also to the Fourth Amendment by doing exactly what your question contemplates. We'd like to think that will not happen, but we know that all these standards, the standards for detention, this kind of thing, are being tested This has been in place for hundreds of years, 238 years under our Constitution, and now in 2025 and 2026, these standards are no longer being universally adopted. I would like to think that assistant U.S. attorneys in eastern Wisconsin, western Wisconsin, and most other districts are still following this, but it is the Department of Justice that has said more and more, don't have to, and we don't regard federal judges as being the ultimate arbiters of these things that they used to be. It's a very important thought, and this is an example of it not being followed. James Madison would be horrified to see what has happened in our nation just recently. I had another question right here. Someone? All right. So that, in part, is the Fourth Amendment. Let's talk. Yes, please. Yes, please.
I'm still a little confused. If it's unconstitutional, how can they just bump their nose at it and people say it's being tested?
Isn't that so? The question is, again, it's the head-scratching question that we always have for the purposes of the recording here. The question is, you're not confused. You're identifying the problem here is what you are. You've got it just right on target. How is it that people who are taken an oath of office to support the Constitution and are told routinely they've been trained in how to do this simply say, we're not doing that, and we're going to put together a separate memorandum that gives everybody else the authority to do that? Where does that come from? And I would offer to you that, again, as you've heard me talk in other settings, the notion that we are in a constitutional crisis, that's another example of it. When you've got one branch of government who simply says, you know what, I'm not going to regard what another branch, which is the judiciary, what they're telling me to do or not do. I'm going to do this on my own. I'm going to say no. I'm going to say yes. That's a constitutional crisis. And so to the extent that you're shaking your head in disbelief, I would offer that disbelief, that head-scratching, is appropriate. It is inconsistent, and I would offer you, too, that it is indefensible, and it's not consistent with what the Fourth Amendment contemplates. And the answer is that some of these judges are not only are condemning, are enjoining, are stopping law enforcement from doing it this way. Again, the memorandum has, I think, all but been rescinded, so we'd like to think they're finally going back to judges right now. And here's the other piece of this. If you are on the receiving end, if you're in the door there, and you are basically the subject, you're the target, I would say that you're the victim survivor of an illegal and unreasonable search and seizure. Can you file an action, what's called a Bivens action, for damages against the government, not only replacing your door, but also for the consequences of the violation of your right? You bet you can. And you can bring that lawsuit against the federal government, against the Department of Justice, for the recovery of monies that or damages you have suffered because of their unconstitutional behavior. You can do that, and that's where some of this is coming from now, more and more. Please.
As a non-citizen, can do that?
The answer is yes, and so the fourth is great question. The question is, can a non-citizen do that? We live in a wonderful nation, and what that means is the protections of the Constitution apply. We can all say this together to citizens and also anybody who's here, residents as well. If you happen to be, frankly, someone who is illegally here, if there is some interest in you for deportation purposes, if you're inside that home and you claim some privacy right to it, which you still can do under the Constitution, and you are, frankly, the victim of inappropriate behavior, can you file a lawsuit? Sure you can. The downside of that, of course, you're also identifying yourself very publicly as someone who's out there, but the wonderful part of our Constitution, at least to this point, again, not without some suggestions coming from areas inside our government that there should be a difference between citizens and residents, but someone no less significant than Antonin Scalia has said repeatedly during his lifetime, during his tenure, that the protections of the Constitution extend beyond citizens to everybody who is here. And again, if you're not here, that's different. That explains in part Guantanamo Bay and other places around the world. But if you are here, our Constitution protects you. Isn't that wonderful? That's a good thing. As long as it's followed, right? That's the point. Yes, please.
When Alex Petty, before he was shot, he was videotaping the police coming at him.
Yes.
And somehow, obviously, this smartphone went on the ground. Somebody confiscated it. Extend that story. What should happen to that item? Could it be searched? Could it be used for evidence? The custody, chain of custody issue,
Right.
all of
all kinds of things here. The question is all about Alex Preddy, who was, again, I would say assassinated on the streets of Minneapolis, one of two people. We've all seen that videotape. Lots of things going on there, and I believe, I'll have to check on this as well, that his family has also filed a civil rights action against the government, raising all of those issues. But once again, the obligation, what should happen is that law enforcement, because all of that, including his phone, I don't recall if he had a backpack, but all those kinds of things, you have just not, this is now a crime scene, and I'm not talking about what he did, I'm talking about his murder. And everything should be preserved, put in bags, and again, all of that should be subject. Even going into his phone is a Fourth Amendment search. All that's got to be done properly. Can I tell you with absolute certainty that the the federal government has cooperated with the Minneapolis police in all that? They've complained overtly about the fact that that has not been the case. And so everything on its head these days. And I don't know what the status of that is, other than to say that all those considerations about preservation of evidence, about claims. What is the allegation in the civil rights lawsuit? It is a deprivation of life and liberty, and the deprivation is murder. That's the deprivation. That's the constitutional claim that you would make. So it's a very good example of the applicability of these kinds of principles. Yes, please.
Now, how do they get around this? The recent decisions they made saying, well, if they show your phone to you and it unlocks, or they make you put your finger on it so it unlocks, it's okay for them to search. But if there's a pin on it that you have to enter, they can't make you do that. They have to get a warrant. What's the difference?
Sure.
How can they make you unlock it? It's okay for them to search it then?
Right. A lot of the question goes to, again, these little computers that we carry around with us and are also recording devices, all kinds of things. A lot of that has to do with, I think we talked a little bit about the protests and the use of a phone in that situation. The answer is, of course, if a law enforcement officer comes up to you and says, I want to see your phone and I want you to unlock it, you are not obliged to do that. You are not. If you are arrested, if you're detained, once again, you ask the officer, why am I being detained? And chances are they will take your phone. Under no obligation to press those buttons or do the face recognition, because once again, that's a search, that you have a privacy claim in that item. Now, it's not to say that a judge may not order at some point down the road, but it all has to do with consent in the moment, and if you choose to cooperate, you can. Of course, I was a prosecutor for most of my career, and when people did cooperate on searches, other things, there's a thing called a consent search. You come to the door, knock 3 times, you open up, and even before an execution of a warrant, if I say, yes, come on in and take a look wherever you want to go, that's consent, and it changes everything, right? Because now I've said, yes, you can search all these places. If I don't consent and you don't have a warrant, that's when all the Fourth Amendment implications come in. And so it depends upon exactly what happens with that phone. And judges will make determinations based upon very specific testimony. Where was the phone at the time? Who was holding it? What was the demand? What was the response? What did you do to try to get a warrant to go in? What did you recover? What didn't you recover? All kinds of things related to those very specific questions. Good. Yes, follow up, yeah.
I thought that they had some recent decisions saying that, no, if the cop shows you the phone and you got facial feature unlocked, that's fine. They can then go ahead and search it. Or make you put your finger on there and unlock it.
Yeah.
That's okay. If it is a pin or whatever, they can't force you to do that.
I don't know about those decisions. And again, even the question assumes an awful lot of particularity, right? I mean, what's happening in the moment? And judges will make determinations based upon that. Again, it's all a question of, we'll chat about this in just a moment or so, about, again, are you in custody too, right? We'll talk in a moment about Miranda warnings and those kinds of things. If you're in a non-custodial setting and the police are asking you to do something, you have the right to walk away and to say, thank you very much, I'm not going to participate in this. If you are in custody and they maintain that you have done something with your phone or it's evidence, then they can probably seize it. But what they do with that next, whether they go in and get a search warrant, whether they compel you to open it up in some way, that's the things of which lawsuits are based, and that keeps lawyers in business, right, on addressing those kinds of things. There was another question about all this. All right, so it's a complicated area, and as long as we're talking about current events here, that's one of them. Here's another, I hope. Well, let's see. Gabby, is there any way that you can advance? I think my clicker may have gone dead. I'm not sure. Oh, there it is. Okay, there we go. Thank you. So here's another one, again from the news. You know about Fulton County. Has been much in the news in the past couple of years. What we have here, and this is, again, is another one, as I scratch my head, I think an awful lot of people are doing the same thing. Somehow, the federal government got a magistrate judge to come to the conclusion that in the official voting records and the rolls and all those things in Fulton County, which just happens to be the site of one of the prosecutions now abandoned by the Fulton County DA there, that there was somehow evidence of a crime, criminal activity, probable cause, and justification to seize and search the records there in Fulton County. And so we got January of this year going into that. There's the location there. They're going in, and the request, the seizure directive is ballots, tapes, data, voter rolls, and that might constitute evidence of criminality in the procurement, casting, or tabulation of fraudulent ballots. Somehow, a magistrate judge was convinced to believe that there is there. We know from 60 other judges out there that this just doesn't happen. And you see some of the language there from the Fulton County Commissioner, among others, who says, listen, this has gone through 3 or 4 different iterations. We've checked, we've rechecked, we've recounted. There is no fraud here, and we want a forensic accounting on all this. We don't want this to happen. I don't know what to make of this other than to suggest that maybe in their underlying affidavit, they raised again all these the conspiracy theories about you see Fulton County, the seedbed of all this bad voting and all the throwing of the 2020 election. And again, the standard should be more than that. I don't know if I were a magistrate judge that I would have granted this, but they went in and they seized all of this. There was some recent activity showing that the FBI director has now that they've got all this information, that he's allocated more special agents to plow through all these ballots to try to find evidence of criminality. Talk about lack of recency, right? It's 2026, and now we're looking at these ballots from years ago. What are you looking for? What is the suggestion? What is the crime that you think happened here? And it defies my understanding about what is going on here. The folks in Fulton County are apoplectic about this, and they want their records back, and they're very concerned that by the FBI taking them, that they will be somehow altered, which again, you'd like to think would never ever happen, but in a world of 2026, anything out there is a possibility. And again, somehow they convinced a magistrate judge to go ahead and authorize their going in to do this. It will be fascinating to see if anything comes of this, who are you going to prosecute, what that looks like. Recognize once again that there is a requirement to go back and report to the magistrate judge on what you have found and what you haven't found. That is still out there. And note also that it's in this circumstance that the former National Security Advisor, Director of National Security, Tulsi Gabbard, went down there in the midst of this. National Security appeared at this site. And again, scratching your head, again, not a domestic matter that she would be involved in. All very, very curious, and one wonders, and again, if when it comes to the presumption of regularity, that this is not really about the search for truth. I'm sorry to comment on this way, but rather it's just to raise this continuing specter that there is that a federal judge found some probable cause to believe that there might be a crime here and simply keeps up this completely unsupported notion that there is fraud in our election process. I don't know. That is a condemning kind of thing for me to say about my own government, but this one also defies understanding. And again, you can, I've never had this happen because we do our homework, but you can challenge a search on the basis that it turns out that the Fourth Amendment probable cause was the product of a lie, a misrepresentation, false evidence. And if you do, once again, you've got a cause of action against the government for misrepresenting what you said under oath was the truth. Who knows where this is going, but once again, no clear answers when it comes to the Fourth Amendment here. Yes, please.
I think we have a problem in Milwaukee ballots from the last election, that they should have destroyed them, but somebody wants to get a hold of them because you could use these mail-in ballots and match how they voted to who sent them in. So they could match who voted for what in that group of voters in Milwaukee. And
So-
supposedly they were supposed to destroy them at a certain time after the election, and they're waiting for them to be destroyed before somebody else gets a hold of them.
Welcome to America in 2026, right? Where we were doing these kinds of things to no clear end. But again, the comment was just about what's going on in Milwaukee and destruction of some documents that should be disposed of. We'll see what happens there as well. So that's again, through an indication of things not going well. Again, going back, you look at all sorts of other Fourth Amendment cases, and we're going to spend some time talking about Fifth Amendment cases and Sixth Amendment in just a minute or so. All of them support this notion that you've got to rely upon a government that's telling you the truth, and that magistrates then rely upon that to do this extraordinary thing once again, which is give you authorization to go into your car, go into your glove box, go into your purse, go into your school, your locker, and again, especially the home. It is a sacrosanct part of our institution and our life in America. When you begin to compromise it by doing these kinds of things, I suspect, you're undermining what James Madison intended. All right. So, yes.
This one, the cause of action, is that the term where if you catch the line or something, did they do that? Did they press that in full?
Plainly, you've got people, absolutely, who are saying just that there's no probable cause here. I cannot confirm for you what the status of their litigation is, but they may well even be waiting to see at some point, these stories shouldn't just go away and never be heard from again, right? At some point, and again, the whole idea behind criminal investigation is some expedited movement on this. If you've got reason to believe that somebody has committed a crime in connection with balloting there in Fulton County, there's also a thing called the statute of limitations. It's 5 years. And at some point, you've got to make a decision to go ahead and prosecute. If you don't, it doesn't necessarily mean that the entire warrant is somehow withdrawn, but if there's a challenge to it, nothing comes of it. That just adds more evidence to suggest that there was nothing here from the first point, and it could be the basis for the Fulton County officials, again, to allege that they have been victimized by an inappropriate search conducted by the United States of America. Right? All right, so let's talk about the Fifth Amendment here as we march through other amendments on our list. And unlike the Fourth Amendment, which focuses on searches, right? You've got one topic. This is back again to the First Amendment. Look at all the things that are going on there inside the Fifth Amendment, and we recognize there are at least 4, if not 5, major concepts there. One of them is, again, we forget about this from time to time, except when U.S. attorneys attempt to indict people on their own. The notion here under the Fifth Amendment is that in the federal system, it is a grand jury, and only a grand jury that can indict you for a federal offense. It's 26 people, and they're responsible, again, for coming together and determining there is probable cause. Yes, there's a way of getting a criminal complaint in place, but, for example, Hannah Dugan, as we talked before, she was indicted by a grand jury. A U.S. attorney, a president, a senator, an attorney general does not have the ability to charge someone federally. Different in the state system. Obviously, DAs and others do that. That's concept number one. Second, notice that no person shall be subject to, for the same offense, to be put twice in jeopardy, life and limb. That's the double jeopardy clause, right? That is the reason why, among other things, that when the government goes up on appeal, along with the other things in the Hannah Dugan case, they cannot challenge the count, the misdemeanor count, on which Hannah Dugan was acquitted, right? You can't, as a government, go in and say, listen, we'd like you to reverse that and reverse the jury. That is done. That would be double jeopardy. Plainly, there can be, there are other circumstances where the government can appeal, but even on a sentencing, they're very narrow, and it has to be, for example, that Judge Edelman committed an overt error of law in doing something, which he did not do here. It's simply because you're dissatisfied with a judgment detention or of some jail time doesn't mean the government can do it. Double jeopardy focused there a lot. We tend to think of it always as being, I'm going to continue to try you until I get a conviction. Well, jeopardy attaches when the jury is sworn, and if in the end the jury finds you not guilty, you are done. As someone who has tried cases, and yes, I've been on the receiving end of many verdicts of finding people guilty, but also juries that return a verdict and say, no, we are finding this person is not guilty, and the case then, you go back to your office and you close the file. There's no double jeopardy, which again is not true of other historical rule of law institutions around the world. So that's double jeopardy. Here's the one we'll talk about. Shall not be compelled in any criminal case to be witness against yourself. That's what we normally think about. That's taking the fifth, right? I cannot, although we'll show you in just a moment another instance of somebody trying to undermine that, I cannot call you to the stand and ask you questions in any setting, a bankruptcy setting, a civil setting, family law setting, certainly a criminal setting, and I cannot compel you to testify. Jim, did you put that methamphetamine lab together? And I can legitimately say, because of what James Madison wrote here, I choose not to answer that question on the grounds that it may tend to incriminate me. And that's it, okay? Now, in a criminal setting, that brings that to an end. In a civil setting, unlike in a criminal setting, if there is a family law lawsuit, or if there is a tort action between parties, and I take the fifth in that right is still preserved. But the difference is that unlike the criminal case, in the civil case, the judge or the jury can impute to me the opposite result. The fact that I'm saying I'm not going to testify can prompt a finding that if you were compelled to testify, you would basically admit that you have done something criminal or close to that. So that it's the imputation of the opposite result. That can happen in civil proceedings. You cannot do that in criminal proceedings, once again, because of this basic standard. And then we got the language we often think about inside the Fifth Amendment, due process, can't deprive life, liberty, or property without due process. And, by the way, if we take your property in any way, government, we've got to compensate you in some way. Huge numbers of cases involving compensation. When the government comes in and says, we're going to take your property, we need this land, and then the lawsuits just begin. But look at all the things inside the Fifth Amendment, easily 4 or 5 different concepts. Let's focus in particular on this Fifth Amendment issue. Again, a very important notion, and it's so important, by the way, that if in a criminal setting, Seventh Circuit law on this, Supreme Court law on this, and there have been prosecutors who've done this stunningly, if during the course of the prosecution, the prosecutor gets up and the judge says, Mr. Santel, call your next witness, and I say, I'm going to call the defendant to testify, boom, you are done. That's a mistrial, okay? Because what you have suggested, of course, to the jury, number one, is that this person, number one, is not testifying. They've got an absolute right not to do it, and it has been interpreted so strongly to mean that even if you suggest that this person should come forward and say something, even if the notion is that we can compel you to do something, keep that in mind for the next 30 seconds or so, that violation is so extreme that you'll get a mistrial. You have to start all over again. That's how important that is. You cannot even suggest, even in closing arguments, a prosecutor gets up, never done this, you're trained to do this from the start, every so often, some young prosecutor or someone who just decides maybe they can get away with it will get up and say, well, here's all the evidence, and oh, by the way, it sure would have been nice if Mr. Santel had testified during the course of this trial. You are done. The case is mistried, and you start over again. You cannot even suggest that there is an obligation to testify against yourself. That's how strong this concept is, and so it makes it all the more incredible when this happens in November of last year. Remember Lindsay Halligan? She was the one. She was a lawyer, and she's a real estate lawyer. She is in, and nothing wrong with that, by the way. I'm appreciative of all the property lawyers because I don't know anything about that, and they do important work out there. But she's inside the White House, and you may recall well that the previous U.S. attorney in the Eastern District of Virginia, right? This is Alexandria, had investigated a couple of people. One of them is named James Comey. The other was Letitia James. And that U.S. attorney nominated and appointed by this president, investigates this for several months upon directives of the Department of Justice, maybe even the president himself. That itself, of course, is inappropriate, but that's the world we live in these days. And in the end, you may recall that U.S. attorney came back and said quite publicly, I've looked at this, there is nothing there, I'm closing the file. And that's what a good prosecutor should do. Typically, you don't even announce that, right? And it's frankly even contrary to the ethics of the Department of Justice to announce that we've had a pending investigation of Jim Santel and now we're closing it. Why? Because you're suggesting that person has done something, right? We don't even do that. But he came forward because of all this focus and because the president has been saying, I need Jim Comey indicted. He came forward and said, we've looked at this. The investigators have looked at this. There's no indication that Jim Comey committed perjury when he spoke to members of Congress a number of years ago. What does that get you from this administration? It gets you fired. And by Friday night, that U.S. attorney is gone. And over the weekend, the president names on an interim basis, keep that in mind, one of the attorneys there in the White House. Her name is Lindsay Halligan, and she assumes the role of United States attorney. Again, with due respect, we'll talk about attorneys in just a little while, and then the importance of knowing what your lane is. I often say to Kristen and others among you, I don't know all kinds of things about the law, and I'm incompetent to do things. With due respect, Lindsay Halligan is incompetent to be a criminal prosecutor. She's never done this at all. And given the importance of things like Fourth Amendment, Fifth Amendment, Sixth Amendment, which we'll talk about in just a moment or so, these are sophisticated concepts. You learn them in law school, but unless you're practicing them, you're not going to know what this is all about. And so she goes in, and on her, I think it was the second day that she is in U.S. attorney position, she's never been before a grand jury at all. She plainly doesn't know what they do. She presents to them maybe a multi-count indictment. We know that gets very messy as well. And as a result of all of the curious nature of this, you may recall the story, which is not here. It's not the point of this particular presentation, but you recall the story where the judge says, I'm looking at multiple copies of the same indictment. Which one is it? And it turns out that the grand jury did not actually see the final indictment, which is a huge error. And so in the end, major problems. But along the way, the judge who's looking at this says, I'm also looking at the transcript. And it appears that the federal prosecutor appearing in front of the grand jury, seeking an indictment of perjury against James Comey, a felony count, that she has apparently told them at least two things. One is, don't worry, during the course of the trial, we'll be able to compel him to testify. Now that is, again, completely wrong, not even close, and the judge refers to those as fundamental misstatements of law, and it is. It's also grand jury abuse, but for something else that happened here, it would have resulted in the complete dismissal of this indictment. You have given the grand jury misinstructions, whether they're intentional or not, about what the law is, and they're relying upon you to tell them what the law is, and she, 24 hours into this job, gets it wrong. Again, I can barely fault her because nobody is helping with this, and she was just told to get this indictment. And then she goes on to say, which is actually, again, for many people, the most curious part of this, she says, and by the way, if you don't think we've got enough, don't worry, we've got more. We're just not telling you what that is, but you should rely. We've got more evidence than what we presented here, so go ahead and sign off on this. And stunningly, once again, this grand jury does, okay? Once again, makes you wonder what's going on there and what things gets to the judge. And you know how this resulted. And again, the only downside of this entire story is these things were never formally adjudicated. Why? Remember all of the continuing problem with the appointments of this president of these interim United States attorneys. And it turns out that there's another federal judge who comes in from another district in the South, and she looks at all this and she says this appointment of her over the weekend has to do with a 120-day period, which the previous U.S. attorney had used up, that this appointment is unlawful and illegal. And so she's got no authority to be there in the first place and determines that anything that she did, including presenting things to the grand jury, including having her name on the signature block on pleadings, all of that is invalid. And in the end, she leaves, and there is calamity in the Eastern District of Virginia. This gets swept along with it because the indictments of James Comey and Letitia James are under her charge. They get dismissed on that procedural basis that the prosecutor had no authority to do this. Again, my regret is that we didn't, and there was another judge who was looking at the substance of this, we didn't get a clear order saying this, as much as the authorization issue is big, this is outrageous. That anybody would present to any finder of fact the notion that you can be compelled to testify against yourself, completely wrong, and the case is done. I could imagine judges saying not only is this case dismissed, but you are precluded from ever charging based upon these kinds of allegations in the future. This is a hugely problematic thing, and there it is. We violated the Fifth Amendment, again, just months ago in this administration. Had enough? Well, let's talk about more, okay? Let's talk about the Sixth Amendment. And again, the basic concept here is, and again, it's a little bit more positive here, but the ultimate notion, you're getting a number of different things. You've got an impartial jury. We'll talk a little about something called Batson down the road. You've got a speedy and public trial. All those concepts are here. But also this notion about due process. You have to be told about the nature and the cause of your accusations. You've got to be able to confront witnesses. This is all the basic due process stuff. There it is in the Sixth Amendment. To have a compulsory process for witnesses, and here we go, to have the assistance of counsel for defense. Okay? Sixth Amendment basically says if you are charged with a felony, and there's even beyond that, you are entitled to an attorney. You're entitled to an attorney, especially if you're indigent and cannot afford one. You know what I'm talking about here, but that's the Sixth Amendment. All these things, again, criminal notions, public trial, all these kinds of things, and you violate any of those kinds of things. You don't tell people what they're charged with. I'll show you a picture in just a moment where, again, that becomes problematic. And you don't give them a chance to call witnesses in their own defense. All those are constitutional violations of the Sixth Amendment. And that's why judges will often bend over backwards, as they should, to permit criminal defendants to call witnesses. I've had situations where I'm going to call my neighbor. Well, what does that neighbor know about this? Very little, but go ahead, call that witness, just because we want to have you have that opportunity to call witnesses in your own defense and also to do cross-examination, a very key notion behind all this. So let's do a little law school right here and see. Here is all you need to know. Well, actually, it's not all you need to know, but it's a lot of what you need to know about the right to counsel. So Gideon versus Rainway. Way back in 1963, there was a great movie involving Henry Fonda. Anybody remember this? And he played Gideon. I think it was called Gideon's Trumpet. And believe it or not, even though it says so in the Sixth Amendment, it wasn't until 1960 that the Supreme Court said, you are charged with a felony where you could be detained and imprisoned, and you're indigent, you can't afford an attorney on your own. You're absolutely entitled to have the state appoint an attorney to represent you. Gideon is the basic core implementation of the Sixth Amendment. It's concerning. I know you're all thinking, it took us until 1963 to tell us all that. Well, again, it's because Gideon was denied that right, and the Supreme Court said, no, the Sixth Amendment means what it says and says what it means. Here's Miranda, 1966. This is one you all know because you watch Law & Order. And every other law enforcement show that's out there, you can all recite Miranda warnings and you get them all right. But among those is a police officer saying, and oh, by the way, if you choose to speak to us, anything you say can be used. You have a right to an attorney. That's the Sixth Amendment when a law enforcement officer says that to you. And again, goes on, if you cannot afford an attorney, we can all do this in unison, right? If you can't afford an attorney, one will be appointed to represent you, right? That's Gideon. That's Miranda versus Arizona. Just a footnote to that, people often think that, gee, if a law enforcement officer arrests me, protesting out there, and brings me into custody and doesn't read me my Miranda rights, does that mean that the case against me gets dismissed? The answer is no. You're all shaking your heads no, and you've got it just right because you're good law students. And the answer is, what it means is that the things that you say, if you have not been given your Miranda rights, those cannot be used, but the prosecution against you can go forward. So Miranda doesn't get you out of the case. It might if the case is premised principally upon your own statements, but it protects your right. Again, your Fifth Amendment right, your Sixth Amendment right to counsel as well. And this goes back to, I have the change, if you will, or today I need to have my phone so I can call my lawyer or that somebody can do that. That's Miranda. In re Galt, amazingly, in 1967. See all these things happening in the 1960s? Oh, for the 1960s and due process and things that were giving people rights, right, going in the right direction. It extended to juveniles, also facing detention. Same kind of concept, right? Okay, they're not adults, but again, if you're going to detain someone, you're going to imprison them as juveniles, that implicates some due process rights. They too should get attorneys to represent them. I spend, as some of you know, including Kristen knows, I spend a lot of time at Children's Court, and my office there looks over one of the areas where a lot of the Milwaukee County young people are, again, temporarily in detention. I always think about in re Galt because they're entitled to an attorney even as juveniles. Angersinger versus Hammond, 1984. Again, we go beyond felonies to misdemeanors. Misdemeanors, of course, less than 1 year imprisonment. And the court basically says, well, even if it's not a felony and you're facing some serious time in prison, why should we make that distinction? And so even for misdemeanors, if you are facing that and you are incarcerated, you have a right to an attorney. And then this is the big one more recently, and there's a lot of litigation about this as well, Strickland versus Washington. This is not only do you have a right to an attorney, but as one of my great friends used to say, you have a right to an attorney who's not a potted plant, right? You have a right to an attorney who's doing something for you, right? And so your constitutional right is not just to have somebody sitting there and taking notes or whispering in your ear. It's to effective assistance of counsel. And there's a huge amount of litigation out there, especially in the criminal setting, about whether or not my attorney, after I have been convicted of the methamphetamine lab that doesn't exist under my property, whether, frankly, he should have called my neighbor because they know that there's no methamphetamine lab, or he should have pursued this line of questioning. He should have done this. And I can challenge the conviction of mine in the court based upon the fact that my Sixth Amendment right to effective counsel was abrogated. And basically, it turns into this situation where you're proving that your own lawyer was incompetent in the course of your trial. There's another lawyer who takes that on. It gets very complicated as you represent the interests of various parties. But that's Strickland, and it requires, again, effective assistance. And to do things, you don't have to do every last thing. There's some strategic judgment calls that you can make. But a lot of that focuses, once again, on that right to effective assistance, meaning it has to be more than just your physical presence there who's showing up for the trial or the hearing. So there's your run through Supreme Court and the extension of Sixth Amendment rights there as well. That's a lot, right? Questions about that? Again, we're going fairly quickly because I do want to get to talking about lawyers here in just a moment or so. Other questions about that, and we can revisit those, please.
Quick one about grand juries.
Yes.
You always see on TV or the movies where somebody gets brought in before the grand jury. They're not allowed to have a lawyer there with them, but they can go out to talk to the lawyer.
Mm-hmm.
But then they always say, well, you answered the first question, so now you have to answer all the other questions. If you hadn't answered the first question, you could have stood on your right to not speak. Where does that come from?
Right. So the question here, again, there are two things there that you appropriately identify. One is that in the grand jury system, it is the bane of defense counsel. They always say, gee, Jim, you get to be in there, and my client or some other witnesses, I am not there. It's the way that this was designed. Again, the idea is probable cause. For what it's worth, there's also an obligation, a presumption of regularity, that if I've got some credible evidence to suggest that this defendant who I'm seeking to indict, if there is exculpating, meaning evidence that suggests they did not do the offense, and it's more than just a statement that, well, at that time I was moonlighting on the planet Venus, that sort of thing. If there's some aspect to it, I have an ethical obligation to let the grand jury know through the agent. I will ask him or her, did the witnesses tell you anything? Well, one of them suggested that he might have been in Cleveland on the date that bank robbery. I've got an obligation to present that. I can also present, of course, compelling evidence to suggest I don't believe that, and we've checked on Cleveland, and there's no record that he's ever been there, right? Just as an aside, you all saw this recent matter involving what I shake my head on, an incredible breach of law enforcement process here with respect to Pete Buttigieg and Chasten Buttigieg and their children, right? Somehow, that got way beyond where it should ever would have been. Where was the investigator who said initially, let's check to see if Pete Buttigieg was ever there in that location? That's where you start, right? So just as an aside, there are basic things that can be done and obligations inside the grand jury to establish exculpatory information. When it comes to, again, a defense counsel, they can stand outside, and I've had witnesses who go back and forth, and basically they're getting advice of counsel. That's Sixth Amendment. They can do it. They just can't be in the room, and I know that that's a significant thing. When it comes to opening the door is what your question really goes to. If, and it's true even in trial settings, hearing settings, if I ask, were you in Cincinnati? Were you at home at the time that this happened? I begin to describe something, and I can always still raise the issue, but I've effectively sort of waived my Fifth Amendment right. I'm now saying things that suggest that I'm telling you a story about the content of what I did, and I'm no longer basically deciding not to disclose something. If I've opened the door, there is something to that notion that, well, then you should be obliged to answer my further questions. That very event, however, will almost always be the subject of hearings in front of magistrates. All right, Mr. Santel went beyond that, and my client then, or my witness said, I'm invoking my right to Fifth Amendment. Mr. Santel directed you to answer the question, and he did. And a judge will often look and determine whether or not that open the door really happened or not. It's a very close question. My own practice throughout 30 years was always, if someone says, Mr. Santel, I'm invoking the Fifth Amendment not to testify, and I will often ask, are there, again, would you do it in this situation? You've seen these things in other recent events involving, regrettably, government officials at the highest level. They will continue to say, invoke the Fifth Amendment, invoke the Fifth Amendment. I choose not. And at some point, the prosecutor or even the civil litigator will say, if I were to ask you questions about where you were doing in Cincinnati in November of 2026, would you continue to invoke that for all of those things? And typically the witness will say yes, and you can get beyond that. If a witness says, Fifth Amendment, I don't want to answer, my response is always, I'm stopping. I'm not going down that road, because I don't want to risk the notion that now I've violated this person's constitutional rights, I've got a prosecution going forward, and somehow it's been tainted by that notion. The bright line is somebody says Fifth Amendment, you stop. And it's only the kind of reckless prosecutors out there, which some of them are, not a lot, but some of them are, who would do that sort of thing. Great questions about this entire process. So there we are, again, right to counsel. Other things related to Sixth Amendment. You'll notice in the quiz question will be Seventh Amendment. We're not going to address that tonight because it's fairly narrow. We are going to talk, however, about the, yes, and here's the picture. Sixth Amendment, what is wrong with that photograph? If I tell you that's March 15th, maybe the 14th of 2025, these are about 285 people who are being boarded on planes leaving America, and you know where they're going, right? They're going to El Salvador. One of the allegations, of course, in front of James Boasberg, who's looking at this a day or so later, maybe even as it's going on, he says, number one, they have not been afforded due process. They weren't told what they were charged with. They were not given an opportunity to appear in front of any immigration judge, much less a federal judge, and right to counsel, right? These folks were loaded onto a plane and scurried off. And Judge Boasberg in Washington, D.C. says, this has all got to be undone. Bring those planes back. And maybe these people should be deported. Maybe they are deportable and shouldn't be here. That's not the question. And, of course, that never happens. Once again, constitutional crisis? You bet, because a judge said, bring them back, ensure the Sixth Amendment is followed, and the Department of Justice, with the exception of one person, never did that, right? There's the photograph, once again, that underscores the significance of the Sixth Amendment. Let's talk about the Eighth Amendment, and this is fairly grisly, and then we'll talk about lawyers in particular. The Eighth Amendment, again, fairly straightforward, unlike some of the others, basically says nothing excessive can be done when it comes to imposing penalties, including things like we saw with respect to Judge Dugan. No cruel and unusual punishment inflicted. That's the Eighth Amendment language. And you should know that for various times in our nation's history, including not too long ago, the Supreme Court has interpreted that, no cruel and unusual punishment, as meaning to forbid any state from imposing the death penalty, okay? And there have been justices, there still are justices in the Supreme Court, who say that under every circumstance, regardless of what that person has done, it will always be cruel and unusual for a nation like ours to impose and to execute you. Life imprisonment, absolutely. That has not always been the case, and in fact, the present state of the law, based upon another case that's not up there right now, is that the Supreme Court then went in the opposite direction. A majority of them have said, and as you know well, have said that no, it's not cruel and unusual punishment. Ruth Bader Ginsburg, among other people, outraged by that during the course of her tenure on the Supreme Court, said it's got to be cruel and unusual punishment for the government, for the state to kill someone because of what they have done. Supreme Court and the law today, and that's why we have executions in various states around the country, the Supreme Court has said it is not cruel and unusual punishment. At the same time, they've often also said in the same paragraph that in order to do this, Texas, Tennessee, Alabama, not Wisconsin, we don't have the death penalty here, you've got to bend over backwards to make certain that everything is done just right, due process, right to counsel, right to witnesses, all those kinds of things, everything, top to bottom. And it's the reason why you see all of these cases, which you'll see some right now, where people have been on death row for 10, 15, 20 years because we're litigating up and down all kinds of things that you probably wouldn't litigate if they were given a very long life sentence. That may or may not be the case depending upon the state. But here we have a situation where this comes before the Supreme Court just this past term, and they're addressing once again the death penalty in America under the Eighth Amendment. We know, again, based on the nature of the law, it is not cruel and unusual punishment to do it. A state can elect to do it, but you got to follow the rules. And one of them is, back in 2002, in a case called Atkins, the Supreme Court says, we are not going to permit any state, no place, can you execute someone who does not have the mental capacity, the intellectual ability to appreciate what's going on. Not only the intellectual capacity to understand what he or she did physically, typically these are horrific murder cases, as you can well imagine, but also if you can't appreciate, if someone says, we're going to put you to death, Mr. Santel, if you can't appreciate what that means as a penalty, the Supreme Court has said we cannot do it. Okay, and the question then becomes, how do you figure out where that person lies? Well, we've got Joseph Clinton Smith, and he is sentenced, again, it's a heinous murder after a robbery, and you can look at the facts of it. There's very little doubt that he did this, if any doubt whatsoever. Again, note that the offense conduct happens in 1997. We're still litigating his case here in 2026, right? So what happens is that the state of Alabama faces this question. His attorneys raise the question. They say, Mr. Smith is not competent intellectually to appreciate what's going on here. He doesn't know what he did. You can't execute him under Atkins. And Alabama establishes its standard that says if you are at a 70, the number 70 IQ, if you're there or above, we can execute you. But 70 or below, then we're going to find as a matter of straight line drawing that you do not have the intellectual capacity, so you will not be executed. What happens in a situation where, like Mr. Smith, you've got tests over a period of a number of years, and they're on both sides of the line, or they're very close? 71, 72, 69, 73, and you've also got someone who sits down with him on a number of occasions and says, this fellow does not have the capacity, intellectual, to appreciate what's going on in his life. What do you do with that? Well, Alabama says, I'm sorry, he's got IQ tests that place him at 72 and 73, 2 or 3 points above, we got to draw the line somewhere, and so we're going to execute him, okay? Defense counsel appropriately brings this up to the Supreme Court and says, this is too close, and the state of Alabama should not impose this kind of penalty under these circumstances. And after all of that send-up, you'll be disappointed to hear that the Supreme Court, it's the only case among the 60 this term, says, you know what, we're not going to decide this. They say that we improvidently granted the decision to review all of this. We don't have enough facts. We're going to send this back down. And so what it means as a practical matter is that Joseph Clifton Smith will probably not get executed there. There probably will be a resentencing here for all sorts of reasons. But the Supreme Court looks at all this and says there's no meaningful guidance that we can give on where the lines are drawn and how you do this, basically because the evidentiary record, which is often the case with these emergency applications as well, is simply not sufficiently complete that we can tell you with clarity what the states should do. And so is regarded as a big case involving the death penalty in America, and we will wait again for some future time to get more exposition on this. They decided not to decide. Kristen.
Is IQ even a real scientific thing?
That's the kind of thing that was also argued. Lots of amicus briefs, lots of people saying, what are we doing here, Alabama? Making this bright line test of IQ? This just should not be, right? And so all of that presumably would have been the subject of some very interesting discussion from members of the Supreme Court about under what circumstances can you execute someone who's very close and you don't know. What are the criteria that you use? That's why this is, again, it's not disappointing in an intellectual sense or in a constitutional sense, but intellectually, it would be good for the Supreme Court to tell us what this means for future states like Alabama who want to execute the next Joseph Clinton Smith who's out there. Please.
Or even just, how did you come up with 70 instead of 65?
Right.
75?
Right? And so you need to be on the Supreme Court the next time this comes up so you can ask the Attorney General from Alabama, where do you draw that line, ma'am or sir, right? Absolutely. Another question right behind.
It costs the state so much more to put these
Yes,
people on death.
we're litigating death penalty.
So why do the states do that when it's going to cost them a lot more money and they end up sitting on death row
Right.
for so many years?
Right, some of your colleagues here are maybe offering some answers here. I don't presume to know that. I tend to agree with you in terms of the expenditures and resources. Joseph Clinton Smith should never see the light of day. He's committed some horrible things. Nobody disagrees with that. But we do spend an awful lot of money for the purpose of pursuing the death penalty in America and be able to say that we are going to execute him, right? I think that's the answer. Fiscally, does it make a lot of sense? Probably not. In terms of imprisonment, obviously you keep him in prison for a long period of time, but that's also the more than rhetorical question. That's what you send a letter to the governor and ask that question, or a legislator there, and saying, why are we doing this, right? Why are we adopting the death penalty at all if we have some concern about whether or not this is really cruel and unusual punishment? Great observation. Yes, please.
What was the rationale of the Supreme Court justices to say that the death penalty was not cruel?
Yeah, so if we, again, had a lot more, there's some fascinating cases out there. I'll give you the specific site, and the answer is just interpretation. Some of it's Scalia-like in terms of what James Madison intended. That's all you got to work on, basically, and it depends a lot. It shows you the reason why presidential elections are important. Why? Because presidents appoint Supreme Court justices who look at that language very differently and say, of course it's cruel to kill somebody, even though they've done this. And of course it's unusual. Well, maybe it's not so unusual anymore, but and others will say, no, it's an appropriate law enforcement purpose, and we've got to send the deterrent message that if you do these kinds of things, you will suffer this punishment, and it's not cruel and unusual. The debates over this case are huge inside those cases in both directions over our history. Please.
So when is this IQ test done? If anybody goes on death row, they get an IQ test? How does that work?
Sure. I cannot tell you that that's the case for all states. I don't know exactly. Again, the opinion, again, the decision here from the Supreme Court is basically a non-decision, so we don't have a lot of that. My guess is there was some administrative decision by the Department of Corrections in Alabama. This is the standard we will adopt. States are given the capacity to make their own decisions about how we do this. And somebody at some point said, following up on Kristen's good point, IQ tests, that should be a pretty bright line thing that we can do. My guess is it was a decision by someone administratively many years ago to do just that. Underscores once again some of the concerns about death penalty impositions generally. Supreme Court waiting for another day to do it. Let me talk about this one being fairly brief here. And it's also a death penalty case. Here we've got, I mentioned briefly in the past, Batson. Here we've got a situation, believe it or not, with the Supreme Court, a case involving Terry Pitchford, also horrific murder of a shopkeeper. In the course of jury selection for his jury over a period of time, the prosecutor specifically eliminates from the pool of jurors virtually any possibility that there could be a black juror on the jury, right? You've got a veneer there. 40% of the county is black. And the prosecutor, who's got a strong record, if you look at this case, it's quite remarkable, is striking all the black jurors. The defendant is black. There's a case called Batson versus Kentucky, which we always thought about during the course of any jury selection in federal court, state court as well. You always want to be very, very sensitive to the notion that if you have a defendant of color, and you want to make certain that the large pool also includes people from the community of different racial backgrounds. If you are looking at a list and you're eliminating all of the Latino prospective jurors or all the black jurors, and you cannot justify it based upon the fact that, for example, they said, I don't like law enforcement, there was something else about their questions. If it's clear that you're doing it just so that all the white people will be more inclined to convict the black defendant, that's racism. The Supreme Court has said that you get an automatic, once again, a reversal during the course of jury selection, and there routinely are Batson inquiries. They're not always successful, but on a routine basis. Frankly, when I was practicing law in this setting, very much sensitive to that. If you even strike one person of color from the pool, I'm fully prepared to explain to the judge why it is I did that, and I better have a reason that's not based upon the race of the defendant. And almost always you can, and it's non-racially motivated. You can say, well, he also said that, yes, he hates the police. All right, that's a reason for not having that person on the jury, but it's not because they're black, and so is the defendant. So here we have a situation where, again, Justice Kavanaugh says, because you didn't, again, afford the lawyer, in the Sixth Amendment case as well, a sufficient opportunity to challenge that process, we're sending it back, we're vacating the judgment. We're vacating the death penalty imposition here, sending it back so he can be tried again. Significant, right? And that just happened here in that death row. And so again, you got to the Supreme Court before they said, no, go back and do this again. Just happened. Please.
What if he said you only, just like some black people?
I'm sorry, what is it?
You were saying exceptions to the rule. What if they ask you, you say, I only, just like some black people or some.
Yeah, so the question sort of is, what if you say something, I think what you're positing is something that's kind of overtly racist, right? If I don't like black people, that will get you a mistrial, that will get you the jury pool dismissed, and probably an admonition about what you're doing as a prosecutor if you're exhibiting that kind of overt racial animus. We prosecute people, we investigate them based upon what they do, not who they are, right? That's a fundamental tenet. We have got... So I'm going to skip through this. Suffice to say there's a huge amount of information here about the ways in which you execute and some difficulties states are having these days when it comes to lethally injecting individuals. And as a result of all that, we've got states around the country that are now resorting to firing squads as opposed to intravenous injection. You may recall that the present Attorney General has also said that federally he is moving toward firing squads for federal defendants who are on death row. Okay. I'm going to save Ninth and 10th Amendments for next time, but they're important, and we promise we're going to get back to them, including federalism and what that shows. Again, we'll keep that in place. I wanted to just do this, and then we'll do a little bit on lawyers. And whoops, I'm going to go that fast. We'll need to get a better battery for this, I guess, down the road here. Let's go back and do this if I can. All right, so as we think through all of this, this applies to everything. Because this is so very serious, a little bit of levity. Here is a couple plainly looking at the news, husband looking at wife, partners looking at each other, and he says, the Supreme Court has declined to uphold a ruling overturning the Ninth Circuit's denial of a stay to block a district court ban. Happy, or are you outraged? Can anybody diagram that sentence? And he makes the point, of course, that there's so many back and forths here. This is a very much more sophisticated way of saying it's a lot, and it's very difficult sometimes to follow exactly what has happened here. We'll keep that in mind as we go forward here. We do want to spend, we promised you some time, to begin at least tonight, some time talking about lawyers. And we're going to do a little bit of that. Whoops, wow. So let's begin with a little bit of William Shakespeare. I know that all of you have memorized Henry VI, Part 2, and it's during the course of that history play that a fellow named Dick the Butcher, he is drawn there. He's quite literally a butcher. He's a part of some ne'er-do-wells, and of course these are fictitious people in the mind of William Shakespeare. And he and some of his rebellion companions, a fellow named Jack Cade, they want to overthrow the monarchy, the government, basically. Again, some history here, but these are fictitious characters made up by William Shakespeare. And Dick the Butcher and these other folks, these ne'er-do-wells, are again, they're violent. They're plainly described as being not too bright as well. But they're going to overthrow the government, and here we go. Let's all do this. And Dick Butcher announces in part 2 of Henry VI, well, the first thing we have to do is we have to kill all the lawyers, okay? And you've heard that often, and it's often said, well, gee, that's a great lawyer joke, right? In fact, it's not. It's just the opposite, right? And again, I'm all in favor of the great lawyer jokes. We'll tell them some other time, maybe even next time. But this is William Shakespeare saying, the way that you ensure anarchy is to get rid of lawyers, right? We kill all the lawyers and all hell breaks loose. And they try to do it. They're not successful here. But the first thing we do is kill all the lawyers is basically a representation by William Shakespeare that lawyers with due humility are the guardians of the rule of law, as are others in the system, including defense attorneys and judges and juries, that sort of thing. So let's talk about what lawyers do. And in particular, the point of this is, we've got a couple of cases. Here we talked before about the Rastafarian, this case in which the Supreme Court said that you've got no remedy under the particular statute. Remember this case? He has his dreadlocks shaved, and he goes away unsatisfied. And you might think, well, what's the connection here? The woman there on the right, her name is Michelle Mickens. She goes in the opposite direction. She is going to get paid $300,000 in settlement of a lawsuit. She used to be an English teacher in the Oglethorpe County School District in Georgia. After Charlie Kirk's assassination, she posts a statement of Charlie Kirk's about the Second Amendment. And basically then he says, well, in a civilized society, we've got to, unfortunately, some deaths at gunfire are the cost of a civilized society. Some gun deaths every single year, so that we can have the Second Amendment. We've got to be able to tolerate that, to protect our God-given rights. A lot of controversy about that. She posts that on her private, personal Facebook account without anything more that is attributed accurately to Charlie Kirk. And of course, he has just been killed by gunfire, by an assassin. The school district fires her for that statement, and she brings a lawsuit. And again, just as the past couple of days, she's going to get paid $270,000 for a violation of her First Amendment rights, another $17,000 for attorney's fees. What do we bring those two together? The point of both of those is they're individual people. And the lawyers represent individuals. They do, again, even Batson was a specific person. Gideon was an individual. All these cases come from situations where individual people come to a lawyer and say, I think I've got a constitutional right here. I think my rights were violated. And again, we've got a different result here. In one of them, in the end, there's nothing more that the lawyers can do or the courts does. In the second one, and lo and behold, her First Amendment rights have just been vindicated. All of that, the point of that is, again, you know this well, all of it done, again, by lawyers who bring these cases. Some of it's brought to agencies initially before it's brought into federal or state court, and they always focus on facts and circumstances. That's why all of our good questions here tonight about how all these things work, they're all dependent upon the facts. And it's easy for me, again, and others to say, here are the big headlines coming out of this. All of them, if you dig deep into them, some of them in the Supreme Court opinions, be very specific, all of them related to particular things that happened, all of them the products of an attorney-client relationship that each one of these individuals have, and their names are now attributed to these cases that we know very, very well. So, what is the point? Again, I've spoken about this, and again, much of this is intuitive. Why do we embrace so much the notion of an adversarial system? Why do we have prosecutors and defense counsel who are fighting, not physically, but quite literally over the law and what the facts are? I've got a couple of a cartoon example and a much more serious example of that. the concept that, again, goes back to the Constitution. It is Sixth Amendment stuff, and it's constitutional right to confront witnesses. The idea is that if you're vigorously debating, if you've got witnesses who you can cross-examine, and you can test the validity of the government's proof, that as a result of that adversarial process, the truth will percolate up. Now, that may be somewhat aspirational and may not always be the case, but it's premised upon the notion that if we're not an inquisitorial system, we just have one person asking questions, we've got two people who are fighting on behalf of clients, different views, that as a result of that yin and yang, that back and forth that happens in every trial, whether you see them on Law and Order or you saw them last December in the trial of Hannah Dugan, as a result of that, you'll be presenting facts to the jury, law that the judge will give, and the notion is that you'll be able to expose biases, assess evidentiary credibility, and somehow, as a result of that, maybe imperfectly, you're going to get a result here. And so, as we begin to finish up here, the last one I wanted to do, and we'll talk more about that in the future, Kristen and I talked about this as well. Maybe the best example of this is John Adams. It's a very young-looking John Adams because, and I suspect many of you know this, you know, of course, there's a Boston massacre. There are numbers of they're colonists at the time. They're going to be United States citizens eventually, but for the fact that they were gunned down by the Redcoats at the time. And what happens is that there's a captain who's in charge of the folks who are firing there, and that captain's name is Thomas Preston. He's charged with murdering 5 colonists, the Boston Massacre. John Adams, future president, future vice president, defends them, and defends them successfully in colonial America. He does a very particularized defense of all this, and along the way, he goes to great strides not to impugn the integrity of the colonial purpose and the mission here, but to describe the reasons why this was actually self-defense, and the reason why there are reasons to acquit these soldiers, and he's successful in doing so. He gets some heat, and of course, over time, he certainly suffers some diminution in his status, but it underscores once again John Adams, a lawyer, again, plainly one of the most strident folks in favor of our own independence. He is defending people. Why? Because that's what defense counsel do, and they're entitled to a defense. It's also significant that during the course of this trial, there's a doctor who testifies about a dying declaration coming from one of the colonists who talks about the fact that the conduct was actually self-defense by the soldiers. And again, it has to do with an evidentiary notion. John Adams uses that concept of dying declaration to get an acquittal there, underscoring again the importance of lawyers in this system. And so let me get beyond that and simply indicate that we have we've got more classes coming up. July 20th in particular, I'm going to have a very special guest, Sam Liebert. He's the State Director of All Voting is Local. I'm going to be talking about the role of government officials, how they interact with each other and with you, and then in subsequent classes on the 6th and the 13th, getting back to the media, congressional representation. We're going to talk about gerrymandering, redistricting, accountability, all kinds of things still in our docket. A lot to do, but we can do it. And for tonight, I thank you so very much for your participation and your contributions, and we'll look forward to seeing you on the 20th. Very good.